digitizes, preserves, and protects India's rich traditional knowledge heritage, including its application in health, agriculture, and intellectual property rights. Her work bridges scientific research and policy engagement, advancing the documentation and responsible use of traditional knowledge for contemporary innovation and societal benefit. Her leadership at TKDL, Dr. Vishnu has contributed to national and international efforts to safeguard and valorize India's indigenous knowledge. We are honored to have expertise guiding today's workshop with us today. I now invite Dr. Vishnu Jesaperi ma'am to kindly take the stage. Please join me in and I also request Bhula Chaudhary ma'am to please come up on stage to felicitate Dr. Vishnu ma'am. Now may I also request Professor Vikas Chaudhary sir, to come on stage. Joining for the celebration of Dr. Vishnu. Bola, please stay on this now. It is only workshop. So please you be with us on stage. We are honored to have our expertise guiding today's workshop. I now invite Dr. Vishnu Satyagiri to kindly take the stage and commence the workshop. Please join me in welcoming Dr. Vishnu Satyagiri.
Namaste everyone. Thank you so much the national teacher is wonderful opportunity to be amongst solutions that this Anubhuti 2.0. It is indeed an experience for my institution, especially seeing all the young people and you're talking about the Thank you so much. Thank you. This workshop and my discussion with Dr. Chaudhary has been on so I have let me say some of my experiences and also whatever we have also learned over the years in the context of intellectual property rights and traditional knowledge. So it's going to be a little long presentation, but I try to cut it short if in case the kids want to have a break in between, we allow that break and then you can continue to have the workshop going. So I'll be talking about the traditional knowledge and intellectual property rights. The first part of my presentation, and I'm going to focus only on the patents. Next slide, please. Yeah, so when we talk about the intellectual property rights, I'm sure we had a wonderful workshop yesterday and we all know what are intellectual property rights, right? Can I have a response? Yes, no? Okay, good. So when we talk of intellectual property rights, what are they? They are rights given by a legal provision. They are through enactments of the government, and it is a legal framework is put into place, and we have to follow those legislations so as to obtain what we call as the our rights over the intellectual property that we have created. Typically, when we talk of the intellectual property rights, what are they? The patents, the copyrights, the trademarks, the designs, the graphical indications, the semiconductor designs, circuit designs these days, and also the plant variety protection. So these legal provisions, what do they provide us? A protection of our intellectual property in a specific period of time. If we talk of patents, it gives us protection for about 20 years. Whereas if you take copyrights, it gives us, if I'm the author of a creative work, it gives the protection over that particular work of mine for my lifetime and 60 years thereafter. If we talk of trademarks, industrial designs, geographical indication, it gives protection for about 10 years, but these can be renewed. Whereas patent cannot be renewed, copyright cannot be renewed. So this is the background of the intellectual property rights. And why is it important? Because if in case we have this legal protection over whatever we have created, whatever we have invented, we can claim monopoly with that particular invention. So when I say of monopoly, what does it mean? So if in case I have an invention and I want to commercialize that, I can have my own company, I can set up my own company and manufacture the product, or I can license it to somebody and then that particular company or individual would create, manufacture the product and then sell it in the market. I get a premium, I get royalties out of it. Or if in case I want to stop somebody from doing something, I can also take intellectual property rights. So this is the essence of intellectual property rights. So now why is it again important in an academic environment like ours? We are all here to study, we are all here to do something, learn something, and then we want to take this knowledge forward. In this context, today, is an era of startups. I think many of these young minds are brimming with wonderful ideas so as to have a venture of your own and you want to, excel in that particular field. So what becomes important? Making profit. For faculty members like me or Dr. Bula Chaudhary, why is it important? It is an important aspect of our assessment criteria. So we have to have papers, we have to have patents, and this tells us that we are doing well in the job that has been assigned to us. And for companies, it is so very important because it talks about the product portfolio. It talks about the strategy that they have in terms of taking these products to the market and reap benefits out of it. For a layman, why is it important? Because somebody is having the intellectual property rights and he or she is able to market the product as well, even be it a company, there are avenues for a job and employment. So the intellectual property rights become very, very important. The next slide, please. But here we are not just going to talk about the intellectual property rights, right? This workshop is focused on traditional knowledge. Typically, when we talk about traditions and culture, how many of you know that the traditional knowledge is so very vast and valuable and it is all very well categorized? Often no, because when we talk of our traditional knowledge, it's been largely part and parcel of our everyday practice in terms of the festivals that we observe, in terms of the food that we eat, in terms of the clothes that we eat, our traditional knowledge, or even the temples that we visit, our traditional knowledge and the appreciation of our traditional knowledge gets limited only to this extent, not beyond. And we don't think of anything specially in terms of protection, intellectual property rights and all that, because we believe this is all for everybody. That is what we say, right? So why is it that we are trying to talk in this workshop something of traditional knowledge and something related to intellectual property rights? Is it important at all? We'll get to hear more of that. So when we talk of traditional knowledge, unfortunately, when we say it's all traditions, it's all culture, still there is no internationally accepted definition of traditional knowledge. What the WIPO has said is that traditional knowledge is knowledge, know-how, skills, practices that are developed, sustained, and passed on from generation to generation within a community, often forming a part of its cultural or spiritual identity. So where, what does it include? The intellectual and intangible cultural heritage, the knowledge that has been passed on through our traditional communities, the indigenous and local communities, and so on and so forth. And as I said, it could be very diverse and very varied as well. It could be the food, the clothes, the agricultural practices, the Indian systems of medicine, and so on and so forth. And where do we get information of knowledge? One is, of course, the oral knowledge that has been passed on by our grandparents and others across in the community, and also in the context of what we are looking at scholars is the text. We call it codified traditional knowledge. We also call the other aspect as the other category as the oral traditional knowledge. The next slide, please. So when we talk of the codified traditional knowledge, I think India has been very fortunate because our ancestors have had the vision to record whatever they have been practicing. So we have this codified traditional knowledge earlier in the context of rock inscriptions, then later on manuscripts. We still have these metal plate, inscriptions and so on and so forth. That's a very important aspect of codified traditional knowledge. Today, under the Gyan Bharata mission, we are looking at manuscripts to digitize the manuscripts, not just digitizing, deciphering the information content from the manuscript. That is again a very important source of the codified traditional knowledge. Next slide, please. So then the other important category is besides the oral traditional, codified traditional knowledge, what we call as the undisclosed oral traditional knowledge is also part of the communities, especially the tribal communities, and we have almost close to about 11% of them. It's like this. Is it okay if I operated it becomes easy? Okay. Yeah. Yeah, so the concern here is that when we talk of codified traditional knowledge, again in the context of intellectual property, right? This is available to everybody because books are available in libraries, books are available in today's context, internet and so on and so forth. So it is public knowledge. Everybody believes that traditional knowledge belonging to any particular nation is knowledge available to everybody to practice, and they will commercialize a product out of that. But when we talk of the oral traditional knowledge, we need to keep in mind that the custodians of that knowledge is that particular individual or the communities, and it is not public knowledge for everybody to exercise and use that. So now the questions do come: who owns the traditional knowledge? Is there a prior informed consent? What is misappropriation? What is attribution? What is benefit sharing? And is it that particular knowledge, is it associated with any cultural identity? Is it associated with any spiritual or sacred identity? And what about the livelihood of the knowledge holders? Next slide, please. So here, when we embark on any kind of academic or research curriculum, the first thing that we do is look at literature. We want to know what is already available, because then we will be able to identify something that would be of interest to us and then do research in. So typically, we talk of, this is called the prior art information in the IPR context. And when you talk of this literature, it is both patent and non-patent literature. So there are primary sources of literature. It could be original research articles, results of the research activities that we do, and also the analysis of the data that we create. Then comes the secondary literature, where we actually look into, the books, the literature review articles, and so on and so forth. The tertiary literature is more of summaries, the samhitas that we consider and all that. It also includes textbooks, dictionaries, encyclopedia, handbooks, and so on and so forth. So traditionally, when we look at literature, it has largely been journal articles, book chapters, and conference papers. But today's context, when we do a prior art literature, we need to be mindful of databases that are being created, patents, copyrights, any IPR, even company reports. These are all part of the prior art literature. Even market reports, the presentation. This presentation of mine would also be considered as a prior art information. And any other creative art form, especially in the context of copyrights. The next slide, please. Yeah, so when we talk of coming back to the intellectual property rights, it is very important to understand that, when we seek intellectual property rights, it has to be something, a new invention, or it has to be something very new, very creative and new to the world around. So in the patent terminology, what we call it as patentability criteria. There are three important criteria. One is the novelty, the second one is the inventorship, and the third one is the use of the particular invention. It could be an industrial application or it could be an application of its own kind. So here, very often in the context of traditional knowledge, people believe that, okay, we know what is novel or what is not novel, but the inventive step is what becomes very, very important, because what inventive step actually means is that you are creating something new which has a technical advantage already known. Using the mindful of it. In the context of traditional so what happens when I create an invention? I go to the patent office, I online and file an application today. And once I file a patent application, we also ask for the search by paying the required cost of it. And then after 18 months, the application is published. And then it goes for an examination to identify this particular patent invention over what is already known as per the patentability criteria. Then it goes to the grant, and at least it then goes to the national validation. You can do it across many, many countries. So this is only after 18 months your invention becomes specific. So this is a key part of it. Next slide, please. But in the context of traditional knowledge, generally buried in the especially when we are talking about intellectual property rights. The importance here is that when we talk of traditional knowledge, and when somebody files a patent application and that patent is granted on it, this amounts to misappropriation. When parlance is used, the terminology used is misappropriation. And when biological resources are used, it's called biopiracy. So what does it mean that somebody files a patent application on our Indian traditional knowledge and a patent is granted to them? It is amounts to misappropriation of Indian traditional knowledge. And that particular invention or patent grant, the other party is using it for their own commercial benefits without taking permission from the knowledge holders, the nation concerned or the community concerned. So this is more of an illegal, unlawful act by the third party, and this, a very serious context of it is, amounting to going into a litigation to see how and why we need to prevent such misappropriation from happening. Next slide, please. So here, as I mentioned, prior art information, and I was saying that we are all very proud because we are, India is rich in its own codified traditional knowledge and also oral traditional knowledge. We have so many people who are still following that traditions and culture and so on and so forth. But in the context of the brand art information, if you go next slide, please. There is something called the PCT minimum documentation. So this is literature, both patent as well as non-patent literature, that a patent examiner sitting in a patent office looking at your application to see whether your particular application has any novel invention or not. And when they go through this, literature and non-prior art as mentioned by the PCT minimum documentation, if they do not find any literature of, even our traditional knowledge, they will go ahead with the grant process because it's not part of the prior art information. And if in case you go for countries like the US, people, it's like split techniques. Yeah, if you want to, there are requirements such that everything that we call as traditional knowledge, it is not oral traditional knowledge, but it has to be in a printed form prior to that particular application being filed. So there are difficulties and challenges to defend our own rights on Indian traditional knowledge, especially considering such requirements from the intellectual property rights perspectives. Next slide, please. So this all amounts to a large story. Because of this, the TKTL has been born. So this way back in the 90s, India signed into the TRIPS agreement. TRIPS is a WTO body, Trade Organization body. It's an agreement under that. And he said that, we will be party to the TRIPS agreement, and we will abide by whatever are the international requirements under the intellectual property rights. So what does it mean? That we have to abide by whatever are the terms and conditions of the TRIPS agreement. Here in India, until then, we were following only what is called recognition of process patents. We never had recognition of product patents, but by the TRIPS agreement, we moved into an era where we also started recognizing products in addition to the processes. And here, while we were in that particular transition, we also noticed that many of our traditional knowledge components also be part of the patent grants. For example, the first example that I'm putting up here is the turmeric for its molding properties. You see, thinking, oh my God, how mundane it could be, how rudimentary could it be that a patent has been granted on something that we use it in our everyday, kitchen. I cut vegetables, I cut my finger also in the process. The first thing that I do is pick up a pinch of turmeric, put it on it, wound and seal, and go over doing my everyday work. Basmati rice, especially in the north, it's a staple rice variety, and we eat it every day. And how come, patents have been granted on some things which is so very well known, today. But you need to appreciate that today we are in an internet era, data overload era. But way back in the 90s, you did not have the internet that you have today. And data exchange was also limited. And as I mentioned, while we take pride in our own Indian traditional knowledge, it is in our own languages, which is not part of the PCT minimum documentation. So the patent examiners went about giving the grant to all some things like this, which we believe is known subject matters. So the only way, because it's a legal provision, if you have to fight a patent grant, you have to go for the litigation process. And even the very simple civil cases, even in India, take so much time and so much money. So if you have to go to foreign countries and then go into a litigation process, it's going to cost you much more. And that is what India did, because we have to defend our rights over our own traditional knowledge. And this is the epistemic justice that we can bring it to the country. And so in India, we had gone quarter litigation. The patent on the turmeric was revoked. So the patient got all the claims of cancer. In the case of basmati rice, because we need to appreciate that, our traditional knowledge can be foundation for, inspiring innovations. So out of the 20 claims in that particular patent application, 17 we cancelled, only 3 were allowed. In the case of neem for its fungicidal activity, the task was much, much challenging because there was no codified evidence of prior information. Largely, the farmers practice it. It's more very well known, especially in India and as well as Sri Lanka. But in the context of something like regulations and the legislation, we need to follow what is already strictly mentioned in the particular act. So in this case, while the name evidence is made available through the farmers and other people, it is very difficult for India to find that because it is not part of a published prior art information. So the US people say, no, we can't take anything that you are giving us prior art evidence. Whereas the EPO, they even had discussions with the farmers, not just from the South India, but also from Sri Lanka. They realized that we, for its fungicidal activity is well known, so they were able to revoke the patent in Europe. So it's the large, fight that we have, challenges that we have. In the case of basmati rice, way back in the late 90s, we spent 7.2 crores as only litigation fees, not minding the other costs that was involved in collecting the evidence and so on and so forth to fight the particular patent. Even recently, the Kilta, was filed. So here it is the bamboo basket that is used for collecting agricultural produce. In India, there was a company that made used a polymeric material to make the Kilta. They filed a patent, they were granted a patent. So there was a litigation filed in the Himachal Pradesh court, and it took 13 years to fight the patent application because this also amounts to misappropriation. Move on, please. So here, as I mentioned, art literature, whatever we call it as codified traditional knowledge, needs to be part of the PCT minimum documentation or available in today's context, at least on the internet, in a format that the patent examiners understand. So while we take pride in the diversity of our country, this way the challenges in terms of preventing misappropriation of Indian traditional knowledge. Next slide, please. So the TKDL, the traditional knowledge system library, it was the first of its kind globally. This is taking and it was established by the government of India through a cabinet approval and under the custodianship of the Council of Scientific and Industrial Research, to which I belong. and the Department of the Indian Systems of Medicine and Homeopathy, which is now the Ministry of Ayush in the year 2001. It's a prior database of Indian traditional knowledge to break the barriers of the language and the format in which our traditional knowledge has been codified. We focus on the immune systems of medicine, Ayurveda, Siddha, Unani, Soga, and also the yoga practices, linking traditional terminologies with modern terminologies using a very important aspect, the USP being the data architecture, the structural framework, so that whatever we include in the TKDL database is standard, uniform terminologies. And this is important, especially in today's context, because when we talk of machine learning, artificial intelligence, which is the buzzword today, you need to normalize data and get to those standard terminologies to draw meaningful analysis to the AI. And today, we are talking about something which is being done 25 years ago, which takes care of all these things. So here, we provide information of Indian traditional knowledge in English and for other UN languages. And as per the cabinet approval, the government of India approval, we provide access of the TPDL only to patent officers that are signed non-disclosure agreements, especially in the context of examining patent applications which would have any relevance to traditional knowledge. In addition to whatever the patent officers do, we also find what is called the third party observations and frequent oppositions. I'll talk about this a little more. Next slide, please. Yeah, so here, while we were doing it, the government of India taking cognizance of the misappropriation and biopiracy happening on Indian traditional knowledge, introduced Section 3(3), which in effect says that traditional knowledge cannot be patentable subject matter. So that's a point that I highlighted. It could be a solo component or a combination of several components of traditional knowledge. If it doesn't meet the criteria of inventorship, you will not be given a patent grant. Next slide, please. So here, not only in terms of something like healthy toxicity, we also saw that there were many people across the world who were also copywriting yoga practices. Okay, and this is a very important case, Bikram yoga case. So he copyrighted sequences of 26 postures into breathing exercises. So the US Court of Appeals looked into it and they said it's not an original creative work and they stopped that. So in this context also, the TKDL works. Next slide, please. And we have started documenting even the yoga practices. Next slide, please. So what do we do in the context of, what I've been talking of patents, misappropriation, intellectual property right, biopiracy, and so on and so forth. So the patent offices, 17 of them, do have access to the traditional knowledge digital library database, but we need to understand that our knowledge is not as simple as I am putting it across to you. It's very complex in itself. It becomes very difficult, especially if you are not familiar with many of the words, to supplement the activity of the supermotor recognition of the prior art evidences. What we do from the CSCR is we look at the patent applications that are being filed. It's an annual work. We look at applications that would have relevance to Indian traditional knowledge. Then we use the framework, what is called the third-party observation of frequent opposition, file oppositions, and thereby we prevent the misappropriation of our Indian traditional knowledge. Next slide, please. So this is the process. The earlier process that I had mentioned was once it is published, it goes through examination and then goes to the grant process. But then the World Intellectual Property Organization and many partners across the world, I realized that the patent grant efficiency is also as important as granting patents. So they introduced what is called the third-party observation of frequent opposition. The third-party observation is available to everybody, even an individual. In case you find a patent application that wherein it is no subject matter and you want to oppose it, you can write to the patent offices with the evidences, documentary evidences, saying why the particular invention cannot be granted a patent. Okay. And we use this framework from the CSCR to KDL unit to find oppositions and we also provide these observations where patent offices take cognizance and we use this framework. What is important about the third-party observation of frequent opposition is that we do not go for a litigation process, so that way we would be saving the country lots of money and also the effort in preventing misappropriation. So here, up to about 3, depending on the different patent offices, up to 3 evidences if we provide for opposing the patent application, it is free of cost. The patent examiner would take cognizance of the evidence that you provided in the context of the invention that has been mentioned. And then if in case he or she finds it useful, they send it to the applicant to respond. If the applicant responds with appropriate data, then it would go through a grant process or otherwise it would be rejected. Sometimes based on the evidences, the patent applicant either withdraws or abandons the patent application. So it helps in the efficiency of patent grant procedure. Next slide, please. So this is something I just wanted to give you statistic. Typically, the patent grants after the grant is given, it is a litigation process, as I mentioned. But there are very few, only about 4% of all patent grants are opposed, and this is statistics from the European Patent Office. And of those that are opposed, only about 35% of them are revoked. About 41% is amended. I'm talking of 41% of the 4%. And the remaining is either rejected or it could be other, outcomes like, abandoning the patent application itself. But if you look at the third party observation, this is far more fewer compared to even the proportional application. But what is also important is if you look at it, the examination is resumed, okay, and then it goes to the application being abandoned. So it's almost like 15 of them. If the patent claims are amended in about 20 of them in a distribution of about 40 applications, and of course some of them go with no changes at all. So we are using this particular procedure to ensure that, especially in the context like this, that in the context of our traditional knowledge, we will be able to prevent misappropriation and bias piracy, which is the primary objective of the traditional knowledge distillery, and thereby serving as a very, very effective defensive mechanism to protect Indian traditional knowledge. So this is how the whole thing happens. In the third party observation, we just file the observation and let the patent examiners take cognizance of it. In a pre-grant opposition, which is the framework in India, you also have to go for the hearing, and based on what you present and what the applicant presents, the patent examiner will take a decision on the patent grant procedure. Next slide, please. So here I just give you one example. This was a application that has been filed by a company from Netherlands, and this particular application used oregano extract to increase the brainwave activity. Next slide, please. So here what we did is looked at the application technique, and then we had identified evidences from the TKDL database, and we provided to the examiner. Based on that, the examiner felt that there are important evidences from the TKDL, and he sent it to the applicant, and the applicant did not reply to the examiner communication regarding the third-party observations, and this applicant was deemed to be withdrawn. So this is how effectively the TKDL works in defending our traditional knowledge from the wrongful patent grants. Next slide, please. So I had already explained about the filter. So this is to explain that while we talk of innovation, we need to be mindful of innovations that is over and beyond traditional knowledge. It just cannot be a copycat and then say that, oh, I have innovated keeping the traditional knowledge as a foundation and I have not been given a patent grant. Next slide, please. Yeah, so here is, you need to understand that, while the TKDL works as a defensive mechanism, it is not to stop innovation at all. Here is a very important example where a patent has been granted by the USPTO without any opposition. So here, what they are saying is that they use Britannia somnifera, which is rich with the retinoids and is used along with the vaccines. So this is, the synergy that one can bring about, and this has gone through a patent grant process. The next slide, please. So here is one more, which is talking about herbal formula containing a Montana leaf extract for the treatment of liver diseases. And these are all the claims. They have used extract of 3 different herbal species, and then they said that this can be used for several diseases in multiple formats, be tablets, capsules, syrups, and so forth. And they also use a very important process for developing this particular formulation. Next slide, please. So based on the TKDL evidences, all the product-related claims they cancel, only the process claim was allowed, and this is how we help prevent misappropriation of Indian traditional knowledge. Next slide, please. Yeah, so this is again one another example, and this trying to give you many examples to say that if in case there is something innovative, something creative, you will still be able to go for a grant. But if in case you are directly infringing on something that is called traditional knowledge, that is where we come in, our role becomes very important, and we prevent patents from being granted. So here again, there's a tamarind seed, polysaccharide for the prevention of microbial infections, and they have used it with other extracts, herbal extracts also. Next slide, please. And we gave, a lot of evidences from the PKDL, and the patent examiner felt that the claims 1 to 7 are not novel and lack inventor's check. So this is how the patent offices, they took cognizance of it, they cancelled out the initial claims, and they allowed only claims which are innovative and where there's substantive evidence of what they call as inventor's check. So this is how the whole defensive mechanism works. Next slide, please. So this is largely about protection of traditional knowledge in the context of patents. I'll take a break and then talk about the framework for the protection. When we talk of traditional knowledge in India, while we realize that it is common knowledge to everybody, especially the codified traditional knowledge. So far that I have talked to you is only about largely patents and one example of copyright. And I said, how do we need to defend patent rights or intellectual property rights on Indian traditional knowledge? But when we are working with Indian traditional knowledge, we also need to see how to protect and promote it. Just defending it is not it will not serve the purpose of, especially the context of NEP, where we are laying so much emphasis on the Indian knowledge systems to move forward. So in the country, we do have important frameworks such as the geographical indications, the copyright, the industrial designs, the plant varieties and the farmers' right, the biological diversity line, and of course the Forest Rights Act. Next slide, please. So when we talk of geographical indications, it's again an intellectual property right. When I mentioned the patent, even that is an intellectual property right. But the difference here is that the geographical indication is a registering mark, certification mark given to a good which has specific qualities to a particular region in the country. So, examples are the Kanchivaram, sari, the Bandar Laddu, and many more. The Darjeeling tea is the most famous of that. So these are all geographical indications. In recent times, we have seen an enhanced registry of the geographical indications across the country. We are standing at 697. I believe this has increased very recently. The data has been issued by the patent office. And out of the 299 agricultural, 475 are manufactured. In fact, from other countries also they file geographical indications for protection in our country as well. And today we also have the GI stores. We have the one district, one product, even in railway stations. These are all methods and frameworks that has been enabled by the government of India to promote traditional knowledge-based goods. Next slide, please. So here, few examples. It could be creative works related to the creative art, such as the musical instruments. It could be, as I mentioned, Tirupati Laddu, Bandar Laddu, Pangalpadi Laddu, everything associated with a particular location or place in the country, including basmati rice from across different states. The Rasgulla of both West Bengal as well as Odisha. These are all protected under the geographical indications. So what does it provide? The geographical indications provides a branding to the product. It also specifies the quality and also the product specifications. Thereby, there is uniformity, standard products that are developed because of the GI. And unless and until you deviate from them, you would be able to go in for that particular branding and reap higher benefits and costs out of next slide, please. So another example is about the Varli print, the painting. So here, the Varli painting, it is largely used in Maharashtra and even Jharkhand and other areas. These have been protected. These traditional components cannot be protected per se, other than for a GI. But you see that next slide, please. There are many variants of it that has been protected. Another example is, of course, the copyright. Today, especially for people coming from social sciences and humanities, they keep wondering that patent is not the right IPR tool for them. So what is it that they can do with regard to the intellectual property, right? So there is the copyright, which largely that protects the expression of ideas, the creative, the arts, especially the literary, dramatic, musical, and artistic innovations. And here it could cover books, it could cover translations, it could cover commentaries, and so on and so forth. Just to give you one example, if I have Charak Samhita, say in Sanskrit, and you are doing it in maybe Santali language, you are adding more commentary to it to make it meaningful. So that is what makes the creative work copyrightable and not the verses per se that have been copied from Charak Samhita. So this is how the copyrights do work. Next slide, please. So here, as I mentioned, the Varli paintings that I talked about, the geographical indication, you can see the variant. Here is a Varney clock, and there is an artistic, this one, dramatic work that has been done. So these are all the different Varney painting, Varney clock, and Varney Ramayana also has been created, and a photo frame. So these are all been copyrighted because they include a creative, component to what is also originally please. So I think in the context of the copyright, I'd like to give you an example of Amish Tripathi. So you look at all the different books, largely he has gathered the input from our, ancient traditional knowledge, and he has brought a lot of creative elements into his writing, and that is why every of his work is copyrighted. So you can see, he's been making millions based on, what he's created. Next slide, please. So the next is the industrial design. Design is again an intellectual property, right? It was given for 10 years and then renewable. It protects the 2D and 3D structures of the invention. So here, even in the context of, traditional knowledge, even the Vaito says that you can have ornaments which can be, protected under designs and so on and so forth. So even this provides a positive framework for the protection of traditional knowledge and also its promotions. Typically when we signed into international agreements like the TRIPS or the CPD or and so on and so forth, we are bound by the elements of that particular international agreement. But those agreements also provide us room to make changes within the larger framework to protect our own rights. As I mentioned, the Section 3P of the Patent Act wherein said that no traditional knowledge can be patented is a sui generis agreement in the Patent Act. Similarly, comes to patent protection of plant varieties and farmers' rights, right? In the international body, all they have is protection of the rights of the breeders and the plant varieties generated from there on. But here in India, we have protection and act legislation that protects the rights of not only those breeders but also the farmers. So herein we have protection of the plant varieties which are essentially derived varieties as well as the extinct varieties. The extinct varieties also includes the farmers varieties. So this is one thing. So a very, very important aspect, especially in the context of intellectual property rights, is the Biological Diversity Act. It is enacted under the Ministry of Environment, Forest and Climate Change. You have a national authority called the National Biodiversity Authority that overlooks the implementation of the Biological Diversity Act. This act stipulates the norms for access and use of the biological resources and the associated traditional knowledge. So if you are filing any patent application based on something that you have used, wherein a biological resource has been used, you need to take the permission of the NDA. Similarly, if you are transferring resource, you have to take the permission of the NDA. If you are commercializing the product and exporting it, again, you have to take the permission of either the State Biodiversity Authority or the NDA and so on and so forth. There are different forms. If you do not fill in the forms and pay the fees, you will not be able to go through the procedure. So this is an important framework that protects not only the innovations that come out of the traditional knowledge, but the traditional knowledge also per se. Next slide, please. So here, again, to what we have done in the traditional knowledge digital library, under the Biological Diversity Act, we have what is called the People's Biodiversity Register. So here, at the community level, at the panchayat level, people go take prior informed consent of the knowledge holders, document the information on the biological resources and also the traditional knowledge associated with it. So the key here is the prior informed consent, because only if you get the consent of the knowledge holders, you will be able to go about the documentation process. The NDA so far has been able to document about 2.7 lakh such entries into the database. This again is a very confidential and content access database. Next slide, please. So I will move on. So these are largely the frameworks, especially in the context of the traditional knowledge of India, both from a protection perspective and as well as promotion perspective. But the most important here is that when we talk of traditional knowledge and the defensive and positive protection of traditional knowledge, there are very important elements that one needs to consider. So I thought I will give a little details into the TKDL work that we do and also touch upon, the ethical aspects related to traditional knowledge. So this is the third part of my presentation. So as I mentioned, the framework such as the traditional knowledge digital library is a defensive form of protection. We do not allow others from taking, patents on our traditional knowledge. That is good. It's nothing, rudimentary. But then the more important aspect is how to be promoted. So that is how the positive protection of traditional knowledge becomes very important. Typically, countries do have so many gender system, but considering the variations and the challenges associated in India, we have not yet gone to creating a legislation on that. But we, as a nation, we do have indirect frameworks that I mentioned previously. Countries like Peru, Kenya, they have all enacted gender systems to protect and provide positive protection of traditional knowledge. Next slide, please. So, as I mentioned, I'll give you a little brief into the TKDL work that we do. So, you will be able to understand and appreciate and see how you can also contribute to the TKDL in the years to come. Next slide, please. So, it's a defensive form of RARA. It's a very complex work. While I mentioned that we do a lot of things, we prevent patents from being granted and so on and so forth. The actual work that goes into it, because I mentioned about the USP, that is the data architecture. I also mentioned that we break across the language and format barriers and so on and so forth. So what do we do here? So as you see, if you take a old book of Charak Samhita, Shiv Samhita, or Ashtanga Hridayam, or any book in Unani or even in Siddha, which is largely in Tamil, you would understand that they are all either shlokas or large verses that are put together. And the language itself is of the old languages, it's very difficult to understand. Sometimes, I feel our ancestors have been pretty smart themselves. Today we talk of patent protection so that others don't grasp, what we have invented. But the verses themselves say that, they don't mention what the botanical species is. They will describe, it has this kind of a fragrance, the roots are like this, and it is grown in this particular region, it smells, or in this particular season, it flowers, and so on and so forth. So a person like me who comes completely from the modern science background, if I'm given a verse and asked to translate it, perhaps I will use Google today and translate something and provide something. But here my primary objective of the TKDL is not to provide you that kind of information. I'm to provide you value-added information. I need to make sure that I make sense of whatever I transcribe. What we do is transcription of the information. So for that purpose, whatever is there in different languages, I need experts like Ayurveda Vaidyas, the Hakims of Unani, the Siddha Vaidyas, the Amshis of Sovarikpa, the yoga experts, the language experts, the botanists, the taxonomists, and of course, because it's an IT platform, we need the hardware experts, software experts, network experts, and we also need IT professionals because it's all meant for preventing, prevention of wrongful patent transfer in data traditional. So this whole thing is brought together in a structured way. And as I said, the USP of the TKDL is the data architecture in itself. We use international patent classification framework where we have the IPC codes, and we created something new for the first time in the world, what we call as the traditional knowledge resource classification code. So what does this resource classification code provide? Next slide, please. Yeah, so we do that with the manuscripts also. There's somebody else has transcribed information from the manuscripts. We pick books from there on and then include the information. Next slide. So this provides information on how to categorize information. The data that is put in a birth. Say, for example, there is milk that has been used. So milk becomes a subgroup. It is based on animal and their products. The subclass becomes the animal. It is for a pharmaceutical preparation. And this particular verse is from Ayurveda. So this is how the classification goes. Next slide, please. And this is how the whole thing comes together. Ayurveda, Siddha, Unani, Sovarikpa. So everything is classified. Go. Just click it, please. Yeah. So to give another example of that of the milk, we have what is called Ashwagandha, the granular soda. It is used in Ayurveda as a pharmaceutical preparation. It's the plant. It's the whole medicinal plant. And we get come to the providing the TKAS with annual somnifera. Whereas in the IPC, it will say either a plant or at best, medicinal plant. So this is the kind of granularity that we go in the TKDL. So as to help examiners, the primary objective of the key is to prevent misappropriation of Indian traditional knowledge. Next slide, please. Yeah, so this is the software that has been created in-house for doing all this. Next slide, please. So this is, I'll just take a few minutes to explain that. So there is a particular shloka on Gudishikwa, but it talks about Gudishri, Mother tongue, Rasna, Panchamonam, Kanishtam, and so on and so forth. So if I use a particular verse and do a Google Translate, okay, it will tell me Gudichi, Mother tongue, Rasna, like a Panchamonam, Tandana, and other ingredients are to be used in the superated stage of Vatajam Surika. Now, as CKDA, if I give this information to, see, even our Indian patent office, and you are filing the patents on Venus paracardiculia glycerin certificate. Now tell me what that this suffices transcription, I mean the transliteration suffices to prevent patents from being granted. The answer is a weak sounding no, because it's not easy for patent examiners and everything which is just transliterated. So what we do is provide all this information to tell what the formulation is all about. So here it is seen as pericardical, glycerin, and other different herbal teas. We mentioned the Ayurveda name, if it is from Ayurveda. We mentioned what is the common name. We tell the botanical species. We go ahead because somebody who is inventing more and above, over and above what is traditionally known, needs to also fulfill the inventor step criteria. We mentioned which part of the plant is used in this traditional formulation. We mentioned which, how are the members of this particular process for which the formulation is brought together, in which format it is given. Here it is a quaff, a decoction. It could be used as a churna, it could be used as a juice, and so on and so forth. So these are all mentioned. Sometimes, those versions also contain information on the dietary patterns. It could be restrictions or recommendations. We mention all of that, patya, and so on and so forth. And then we say how it is cleaned and prepared and so on. And for patent officers like the USPTO and WTO, we mentioned the bibliography. We of course mentioned for which it is used. Here it is small form. We also provide the picture, that scanned image of that verse. So as to tell other countries, yes, this is part of our traditional knowledge. So this is the entire work that goes into the PPTS. Next slide, please. So similarly across different areas, this is from Unani and medicinal family. Yeah, this is from Siddha. Next. This is again for cosmetic preparation from Unani. Next slide, please. This is a device tool from Suvaratpa and Koti, surgical instruments, surgical procedure, Siddha practice, Dharma. You might have heard of Panchakarma, yoga practice. So by this, we have been able to document and transcribe close to about 5.2 lakh formulations and practices in the CPDL database. It is one of the largest international. It's also the part of the initiative from the Government of India, done by the CSIR and Ministry of Knowledge. We have expanded scope. When we started the CPDL, we focused only on Ayurveda, but we added the different systems of medicine. Thereafter, besides the formulations, we started including other information like therapy, surgical methods that I had just. And what is remarkable about all of this is that because I'm in the CKD, I was like, what was traditional knowledge from India and what's the information there? But only after I had joined this and taken over the responsibility, I actually appreciate the vastness of our traditional knowledge. And if you look at the codified text, the range of information has been categorized into chapters and specific information is really remarkable. And I advise all of you to at least have a look at it. If you come to Delhi, do visit the TKDS, will showcase that. Here, as a meeting of primary objective is preventing misappropriation. So, in addition to what the patent office is recognized as no motor evidence is from the TKDA, we also find the third-party exhibition. We have been able to prevent patent grants from coming in the chemical house of patents, and it's still going in an increasing. So here the outcomes are typically patent is rejected, application is rejected, sometimes early times it has been revoked, and of course the amendment of the claim, sometimes the applicant either withdraws or abandons the patent application. And as in the case, 7.2 crores is not a small amount for a patent litigation. In 375 such cases, we have been able to prevent litigation from happening. So this is one another example like I showed. Here is from our own country, a company has filed a patent on the use of bakuchiol and along with alinsatirone, curcumin and zingiber officinal. Next slide, please. So based on the evidences, the application of skills now. So this is how the entire TKDL works as a defensive protection of traditional knowledge. Please. So coming back to the oral traditional knowledge, it's a very complex and challenging part. Next slide, please. Here, when we talk about documentation, that I have mentioned is all text from codified traditional knowledge from the country. But when we talk about oral traditional knowledge, it's really very vast, very diverse, and people are not coming forward to share their entire knowledge with people who are interested in. Of course, there are many efforts like ethnobotanical work, ethnomedicinal work, ethnopharmacological work, and so on, and ethnoagriculture work, and so on and so forth. But the entire information is very difficult to obtain. The other key is that the concern of the knowledge holders is that perhaps they will be at the loss of their own livelihoods if all this information goes into documentation and made available to third parties. So here, even organizations like the World Intellectual Property Organization have recommended certain important practices. The UN bodies like the Convention on Biological Diversity has also emphasized on the importance of prior informed consent and also benefit sharing. So here, the key elements are prior informed consent, attribution of the knowledge to the knowledge holders and not claim it as ours. Make sure that the benefits that we read out of, an innovation based on oral traditional knowledge, the benefits are shared with the concerned knowledge holders and so on and so forth. So there is a toolkit that has been also proposed by the World Intellectual Property Organization. Next slide, please. So here, what we have done is that we looked at all the efforts from across the country and realized that, while few people, few organizations do follow ethical guidelines, there is nothing in common across the country. So we took it upon ourselves as a responsibility to protect people's rights. And here we talk about the respect and sensitivity towards this. The first is, of course, as I mentioned, free and prior informed consent, where we understand the objectives of the documentation, we explain it to the concerned knowledge holders, we understand what are their expectations, we come to an understanding that what we are going to do by documenting and what they are expecting are on a common platform, and after that we go over the documentation process or even further R&D. When you do R&D and productization, attribution becomes very important. You need to understand if you are publishing the paper based on ethnobotanical work and you are not talking about the people, you have gathered information from somebody who are the knowledge holders. Just think about the unethical aspect of it. So here the emphasis is about acknowledging the contribution of the knowledge holders. If you are publishing the paper, make them authors as per whatever is the contribution of those people. If in case you are developing an innovation and filing a patent, they need to be inventors on your patent application. If you are productizing and commercializing, you should also think about partnership or ensure that there is an appropriate access and benefit sharing. So the terms and conditions of the access and benefit sharing should be told in the very first step, that is the prior informed consent. You may arrive at the details, the money or other components at a later stage, but this broad agreement should be made in the very first step. So this is a guidance document that we are talking about. Next slide, please. Yeah, that we had brought up, and we are hoping that the learning warriors CSC are looking at it, and we would make it available for everybody to use this as a guideline for institutional mechanisms so that we conserve not just the habits but also the knowledge associated with it, and ensure that the livelihoods of the people do not get compromised through such efforts. Please. So one very important example on this, the access benefit sharing, is comes from the JNTPRI laboratory in Thiruvananthapuram. So here it is the first model of the access benefit sharing mechanism before instruments like the Convention on Biological Diversity and the Biological Diversity Act in the country also came in. This is in the year 1994. So Dr. Pushpangaran was the lead scientist in this effort of ethnobotanical survey. He went about along with a few scientists into the forest of Kerala to look at all the botanical species, document that and all that. So as they were walking through the forest, the scientists asked the scientists got tired and they were taking slow steps. So there are two forest the dwellers, the people who accompanied the scientists into the forest, for the 2 or 2 days, and they were all active and energetic all the time. So Dr. Pushpanga then investing, realized there's something different. While they were tired, they were not able to move forward. These people were fully, energetic to complete the whole survey in a day. So he asked them, what is it that you are eating? So that is how it led to the Trichophil serranicus species being identified. So the drug Jeevani. The drug Jeevani and the new process was prepared. And the process was transferred from the research organization to the Aryavaidya pharmacy. And in all of this, the the Kani tribe, the forest dwellers, were given the benefit. So this is the first case of, the premier, royalty, everything being paid to the Kani tribe. They formed an association and they reaped benefits out of it. So India has been the foremost and, on the front of many different elements and frameworks related to traditional knowledge. And with all your interventions and your contributions, I think we can take India to a higher level. Next one, please. So again, a few examples under the National Biodiversity Committee also. They have a framework, they have a mechanism in which, everything has to be paid. Right from a company like PepsiCo to National Remedies, you also have an individual Gita Pavar, or Ayurvedic doctor who provided the benefit sharing under the NDA mechanism. This is to say that, we need to follow ethics while we talk about intellectual property rights and so on and so forth. Next slide, please. So why is it all important? Because of the sustainability of it goes. No knowledge, which is the foundation of any country can be left apart. India has grown on its traditions and culture. Even for the sustainable development goals, the culture and traditions are going to be very important, be it education, be it health, or be it, in any other aspect of even education. These are all going to be very important, and this is where we feel that we all can come together and make sure that the Indian knowledge system is lively, creative, and innovative in the years to come. Thank you so much. Please, next slide. Take your questions. I'd be happy to answer any questions.
We identified by his own common sense that it might be a traditional knowledge-based patent application. Will that application come to you directly from patent office to verify whether it's a traditional knowledge?
No,
Or
we
whether
don't
I
have.
should seek you are forwarding to that?
No, we don't do that, but what we have enabled the patent offices to do is when they search, because even the Indian Patent Office has access to the TKDL under the NDA agreement. So what we have enabled through the agreement is that, say your patent application has a component of traditional knowledge which you have not cited or you are not aware of. So we have allowed the patent offices to share only that particular information to the applicant so that he or she can look at, what is the evidence. And in case there are scientific experiments that you have done to prove that there is either, synergy or an enhanced activity or reduction in toxicity, if you are able to provide that kind of experimental evidence to the patent office, they can go ahead with the grant because you are claiming something over and beyond, not mere validation, but over and beyond some kind of synergistic effect that you are able to do, then you will go for a patent grant.
Then how will you come into picture in this process?
We are like, the backbone in the context of preventing patent from being granted. So we have a mechanism where the patent offices, either we can search and see where what TKDL has been referred in the context of patent examination. We take that as our, outcomes. And outcome in the context of course, the final decision of the patent authorities. In addition to that, we are also filing these, patent oppositions, the third-party organizations and pre-grant opposition. We keep track of that.
And the opposition stage you are coming to.
Yes.
I'll ask one more question to them on behalf of everybody. In general, as public, we feel patenting means keeping the knowledge secret.
That's not right.
So patenting is not good. This is our purpose. You may kindly.
It's not true because if in case, say there are laws for opposing patents, okay, one of course is the prior art information, but very importantly from patent perspective, either incomplete disclosure of information can also be grounds for apprehension. Say, for example, if you are thinking it is a secret and you hide certain information, and I get to know that you have hidden this information and have not disclosed it, I can write to the patent office saying that he or she has not provided the entire disclosure. So then, your patent, even if it is granted, will go through a revocation. No, Sandy, thank you so much. It was wonderful. First a comment, then a question. I really appreciate what work you're doing at TKDL. And we really need it, knowing how many more back in the etc. So you have to get back what is asked. Second is a question both to you and Navranda who is here. My doubt was when we say that our knowledge in the world, there was no IP and we shared it. Knowledge is to be shared with everyone. At the same time, people keep saying certain community didn't share the knowledge, they kept it to themselves. But it is only restricted to, let's say, a Brahmin community. Whether it's a weaver or a goldsmith, they also have, in a sense, an IP. They also share their knowledge with other documents. Given this complex situation, I'd like to ask either or both of you about IP in the year, in the past. Now we need it. We may be going against the grain of our dharma by having to do this. I don't know. So I just want to know. Will I give my response more from a perspective of intermix of traditional and as well as the emerging global competition, especially for the science and technology. This area is to a large extent, but we also need to understand that earlier days, there have been cases, say for example, a sculptor has done something very beautiful work and they did not want that to be duplicated or replicated, they would cut his hands off. So that is, form of preventing others from copying. Exactly the same. So those have been, very drastic measures that have happened in the past. Not going to that, but beginning at an intellectual level. What we pointed out is very important. Have been texts, there have been largely oral traditions. There will be a certain group of people who would come, and within families they have maintained. As I mentioned, even now, the oral traditional knowledge is maintained within a particular community. Even the, what do you call the bone setting, put the bone setting, even though they don't share the information, you can go, you can smell, you can get to know that there are certain herbs, the active formulation is still a secret. So those, for modern terminology, it's for the trade secret, not the patent, it's a trade secret. Okay? So that is largely about this intellectual property rights came only during the industrial revolution that happened. So especially countries from Italy and of course UK and all that, they wanted to protect their own right and prevent other countries from copying whatever they had done, the intellectual property rights scheme. Today, even traditional knowledge is never started with a dynamic. Even if you look at the old time, the year, okay, things change with the, the ecology, environment, or even if I talk of Ayurveda, it's been practiced across the country. But if you look at the formulations, it all is about the local resources available. Say I have a fever, maybe I'll be treated differently in South India compared to what is being done in North India or in the West and so on and so forth. So these have all been the practices. So now with this emerging and dynamic knowledge system, we need to move ahead with time. Global competition is something that is very right in front of us. So we need to respect whatever is happening globally because we need to be part of this global community. So intellectual property rights need to be
Thank you very much, ma'am. Can we have a big round of applause for ma'am? Looks like an involving committee worker. Education has truly, education has truly enhanced our understanding of intellectual property rights and in the knowledge system, and has given us valuable perspectives to carry forward in our academic industry. Thank you, ma'am. But with our schedule, I would like to inform all participants that session 456 take place at the academic block beginning from 15 minutes onward. Session 4, Health, Wellness and Holistic Living will take place at Boardroom Academic Block. Session 5 will be a parallel session, Philosophy Aesthetics will take place at AV Room Academic Block. Session 6, parallel session, IKS Innovation and Global Pathway take place at Seminar Hall Academic Block. We kindly request everyone present at the venue on time for the next academic session. Thank you for your cooperation. Dear students and dear participants, I invite you to stay with me. Please give your valuable feedback by scanning this QR code. Thank you.
बंद कर दे देख पाँव इस पे पाँव में रुकी वायर के ऊपर से निकल भाई ये भी
क्लास की इनका बच्चे क्लास है कि नहीं अपनी
आज नहीं